Law here at University of Cincinnati, and it's my pleasure to welcome you, albeit virtually, here on this Constitution Day. Now, before we get started, here are the ground rules for this virtual discussion. Please mute your audio and your video. I am going to introduce Professor Hasen, ask him a few questions, and then open it up to questions and answers. You may type your questions into the chat. Okay, so with that, and it looks like we've got pretty much everybody who's registered on board, let us get started. Our annual observance of Constitution Day commemorates the signing of the Constitution on September 17, 1787. And we celebrate that day every year by inviting the nation's leading scholars, judges, and practitioners to give a college-wide talk. Making this event possible is Cincinnati Law alumnus Lewis Katz, class of 1973. He established the Alfred B. Katz Constitution Day Fund in memory of his father, himself a 1935 graduate of this law school. And so because of the Katz Fund, we have had such leading lights as New York University professor Melissa Murray and DC Circuit Court of Appeals Judge Robert Wilkins, and now today, Richard Hasen. Richard Hasen is the Chancellor's Professor of Law and Political Science at the University of California, Irvine School of Law. The legal scholars among us know Professor Hasen through his prolific and thoughtful writings, particularly in election law. Many more Americans are being introduced to Professor Hasen through CNN, which recently named him as an election law analyst. Professor Hasen is a nationally recognized expert in election law as well as campaign finance regulation, writing also in the areas of legislation and statutory interpretation, remedies, and torts. He's published numerous books and articles, most recently, Election Meltdown, Dirty Tricks, Mistrust, and the Threat to American Democracy, which was published by Yale University Press. Professor Hasen was named one of the 100 most influential lawyers in America by the National Law Journal and one of the top 100 lawyers in California by the Los Angeles and San Francisco Daily Journal. His op-eds and commentaries have appeared in many publications, including the New York Times, Wall Street Journal, and the Washington Post. Professor Hasen holds a BA degree with highest honors from UC Berkeley and a JD, MA, and PhD in political science from UCLA. After law school, Professor Hasen clerked for the Honorable David R. Thompson at the U.S. Court of Appeals for the Ninth Circuit. I am so pleased that Professor Hasen could join us today for a conversation about the resilience of our electoral system. So, welcome, Rick.
It's really great to be with you, and I'm sorry we can't do this in person, but I'm glad we get to have this conversation nonetheless.
Me too. Let me unmute my video so that we can at least see one another.
Hello.
Hi. All right. So this election day, I'm thinking a lot about the sanctity, really, of the vote. I'm a kid of the 60s, and my parents sort of drilled into me the importance of the vote. And I have images of John Lewis, of the late John Lewis, sadly, and countless others being beaten by police on the Edmund Pettus Bridge seeking the right to vote. And then, of course, last month, we marked the 100th anniversary of ratification of the 20th Amendment, which gave women the right to vote. And in this context, too, women put their lives on the line. And yet, as you stated, very modestly, I would add, in a forthcoming article, constitutional protection for a right people literally have died for is, your words, not robust. Why?
So that's a great question, and I think it's a really appropriate one for us to talk about on Constitution Day, because it's important that when we think about the Constitution, that we're not only thinking about all the great things about the Constitution, but the Constitution's flaws. And I think when it comes to voting rights, the Constitution does not provide very strong protection for voting rights. And I think that for people who have not studied the Constitution, this would come as a surprise. Our Constitution is pretty old compared to the Constitution of other democracies. Many other democracies, other countries, in their Constitution itself, it recognizes a right to vote. But you won't find in the Constitution, for example, the right to vote for president. You might be surprised to learn that under the Article 2 of the Constitution, which sets forth the Electoral College, state legislatures get to set the manner for choosing presidential electors. And the Supreme Court, as recently as 2000 in the Bush versus Gore case, which ended the Florida recount in that disputed election, said that state legislatures could take back the power at any time to appoint presidential electors directly themselves, meaning that we, the people, do not have the right to vote for president. It's just something that state legislatures have given us. Also, most of the rights in the Constitution, in terms of the right to vote, are framed in terms of the negative. So, for example, you have the 15th Amendment that says if you're going to hold an election, you can't discriminate on the basis of race. Or the 19th Amendment that says if you're going to hold an election, you can't discriminate on the basis of gender. So these are rights that are not robustly protected. And then we leave it to the courts to decide how to balance. And so right now we're in the midst of this pandemic, and there are all kinds of lawsuits, hundreds of lawsuits actually, over how our rules might be changed to take into account the fact that it's harder for people to gather in person. It's harder to gather signatures. If you're a candidate trying to get on the ballot, it's harder to vote. How do we balance that? And courts have just a lot of discretion over that issue. And so it shows that the Constitution itself doesn't limit what judges can do, doesn't limit what state legislatures could do and election officials can do in terms of limiting our right to vote. So now, 240 years after a Constitution is passed, 50 years after the Voting Rights Act, more than 50 years, we're still in a position where voting rights are the subject of constant battle.
Yeah, and that leads me to my next question. Then you said it's a very highly contested area, which is again something one might not expect in a democracy, particularly this democracy, one where we prize democratic principles. You also talk about, again in this forthcoming article, that there is a Republican view of the right to vote or of the vote itself, and a Democratic view of the vote itself. And here, when I read that, I immediately thought about Barack Obama, former President Barack Obama, before he was president, when he made his big splash at the Democratic National Convention saying there's no red states, there are no blue states, it's only the United States. Why is it that we have red concepts of voting, blue concepts of voting? Why don't we just have one concept of what it means to vote in this country?
Right. So I think that there are two different things going on. One of them is that there's a political disagreement between the Democratic Party and the Republican Party. It wasn't always this way, but in recent years, what's tended to happen is that the Republicans have built their electoral coalition over a smaller number of voters. They expect older, whiter, more rural voters to be part of their coalition. And their thinking is that having a smaller electorate will help them to stay in power. And Democrats are thinking the broader, the easier we make it for people to vote, the more people are going to vote for Democrats. So there's this political dimension. But that's not what I'm referring to in my paper. It's more of an ideological disagreement that I wouldn't say necessarily divides Democrats from Republicans, but divides liberals from conservatives in terms of thinking about what is the purpose of voting? And I think there are two different conceptions of the right to vote. One conception of the right to vote is that what we're trying to do is to make the best choices for a society. That is, we're trying to figure out how do we pick the best leaders, or how do we make the best decision if we're in a state that allows us to vote directly on legislation through a ballot measure, through an initiative. And if you take that view, then you might say, well, maybe it's okay to put up hurdles in terms of people registering and voting, because we'll make sure that the people who are the most interested or the most competent are the ones who are going to be able to actually cast a ballot. Syndicated columnist Jonah Goldberg has argued, for example, that we should make voting harder for everybody because it shouldn't be so easy. It should be something that people have to work for. The other conception, the one I'm much more sympathetic to, the more liberal conception of the right to vote, is that what we're doing is dividing power among political equals. And we can't say you have to be able to read, or you have to be able to speak English, or you have to watch the PBS NewsHour, or you have to attend law school, or whatever it is, in order to be able to exercise your political power. What we say instead is we can't decide. Other than saying, you have to be an adult, you have to be a citizen, you have to be a resident. Beyond that, we can't really draw distinctions and say, this is who should be entitled to vote. Instead, voting is about dividing political power among political equals. Your vote and my vote and the vote of anyone else who fits into the category of eligible voters is equal. And therefore, stumbling blocks make no sense. And so, it's a different conception. You can go back 40 or 50 years, and you'll still find states that were using literacy tests. Now, lots of these literacy tests were imposed explicitly for racially discriminatory reasons. But and the Supreme Court has said if you're doing that, it's unconstitutional. It's violating the 14th and 15th Amendment. But what a lot of people don't realize is that the Supreme Court in 1959, in a case called Lassiter versus Northampton, the court said that a fairly applied literacy test is constitutional. That ruling has never been overturned. It's very much in tension with later cases that the Supreme Court decided. And I always start my electoral class by asking the students, if we could eliminate race discrimination and we had a fairly applied literacy test, you have to be able to read, maybe you have to be able to read it, we won't say just one particular language. Would that be okay? And what I find is almost every student rejects a literacy test today. But, we're not that far off from that. And just thinking, what would be the point of a literacy test? It would be to make sure that that someone is competent enough to get information. Now, maybe today people get information not by reading. Maybe we say, you can't be on Facebook more than this many hours a day if you want to be able to vote. It's just really impossible to say what the standards should be. And once you start saying that the government has the right to decide who is worthy enough to vote, I think that takes us down a dangerous path. And I certainly think it shouldn't be inadvertent problems in terms of being able to navigate a bureaucracy. So, for example, most of us have a driver's license or another piece of photo identification, but some people have a really hard time getting that because they're poor, they're on the margins of society, maybe they don't drive, and they live in a rural area, they don't have easy access. Do we really want to say that those people should be disenfranchised because they can't, get over these hurdles? And so I think, we have to decide what is it that our voting system is trying to do. And I think if we start from the position that every eligible voter, but only eligible voters, should easily be able to cast a vote that will be fairly and accurately counted, then I think we're in a good starting place.
Okay, much there. I kind of heard a little bit in your discussion about these two concepts of voting, these two visions of it. That it's not just politicians who have those views; it's also the court, don't you think? The Supreme Court. In making those determinations. And it seems also connected to the very first question. It's this contested view of voting that helps to account for the lack of robust protections. I mean, in some cases, I feel that, the court may be hiding behind, well, it's not justiciable. It's a political question we cannot answer. But in fact, it's something, if the court were to venture into this area, they would be guaranteeing, as you say, that all voters are standing on the same playing field. So does this view of voting also translate to the courts?
I think in some senses it does. And we saw this play out a bit in the dispute. You may remember back in April, Wisconsin held a primary. This was the same primary that Ohio, same time period, early April, that Ohio ended up postponing their primary. In both Ohio and Wisconsin, the governors tried to postpone the primary, but in Ohio, the governor was successful, in part because there was unified government. You had it was all Republican government, and so there was more agreement. And in Wisconsin, there was not. But what happened in Wisconsin was that the Democratic governor very late tried to delay the election. He wasn't able to, and there were lots of reports of people trying to vote by mail because they did not feel safe to go out in the pandemic. This was the beginning of the pandemic when we were still learning a lot about masks and social distancing and all of that. And there were these pictures of voters in line in Milwaukee. There were 175 out of 180 polling places. That's 97% of polling places in Milwaukee were closed on election day. It was just really a dire scene. And there were a number of disputes that went to court. One went to the state Supreme Court over whether the governor had the power to delay the election. The Supreme Court divided along ideological lines and said the governor did not have the power, and the election went ahead. But there was another dispute that went to the United States Supreme Court on an emergency basis. And this was over the fact that given so many people were not getting their absentee ballots in time to be able to return them, a federal court had extended the time for the return of the ballots. And the Supreme Court partially reversed on a 5-4 vote, with all of the conservatives saying, let's stick with the rules as they were written. It's not for the courts to be making changes. This is ordinary litigation. And the dissenters taking the view that this was an unprecedented pandemic. The right to vote is so precious. We should be able to bend the rules a little bit in order to accommodate people who are trying to vote in the midst of a pandemic. And so I think that this case, which is called RNC versus DNC, and I write about it in the article that I think was distributed to your attendees, the article that's just appeared in the Election Law Journal, 3 pathologies of American voting rights illuminated by the COVID-19 pandemic and how to treat and cure them. You can find that online at the Election Law Journal for free. They're making that freely available, so you can download that if you don't already have it. But I spent a lot of time in that paper talking about this RNC versus DNC case and how this represents two views, two very long-standing views. One is, and it's the one I'm more sympathetic to, put a thumb on the scale to favor voters whenever possible. In a case of ambiguous statutory language, always side with the voters and expanding voting rights. But the other view is, and I think there's a lot to this, that it's important to have a fair election, that you stick with the rules of the game as they are written. And ordinarily, I think it's a very strong principle. I think what makes it a hard question here is we were dealing with an emergency that was not caused by anyone's dilatory conduct. We were dealing with an emergency that was caused by an external threat, this pandemic, which created a real sense that people's voting rights were in danger. And we saw this play out in the lower courts as well. When you engage in the kind of balancing of rights and interests that courts do all the time when they're engaged in constitutional adjudication, how much do you take into account the unprecedented nature of current times versus how much do you say, people will just have to deal with the rules as they were written beforehand, because if you start changing those rules, you might give one side or the other some kind of political benefit. And so I think that really plays out a lot. And, the other thing to say, the general point is that judges live in the world. They are human beings. And, if you are, I wrote a book about Justice Scalia a few years ago, and he talked about how he no longer subscribed to the Washington Post because he found it shrilly, shrilly liberal, was his quote. And he said he got most of his news from talk radio. And I think he also said he read the Wall Street Journal. But what occurred to me is that the justices today and judges today are getting their news just like us from sources that we're most sympathetic to. There's a little bit of an echo chamber problem. You tend to, if you're on social media, get messages that reinforce what you already believe, less than what you don't believe. So if you're a conservative justice and you're getting a lot of your news from Fox News and you're hearing a lot about voter fraud, you might have a very different view than if you're watching Rachel Maddow every night on MSNBC and hearing that voter suppression is a huge problem. And so I think we have to recognize that these judges are living in society too, and they're susceptible to the same kinds of messages. I don't see these cases where the judges are dividing along party lines as the judges being party hacks. This just happened in Ohio yesterday, where I don't know, they're pretty unprecedented. There's a dispute right now in Ohio over whether there can be more than one drop box for dropping off ballots, absentee ballots, dropping them off during the early voting period and on election day. And the case went to a state court judge who issued a declaratory judgment and said that the Secretary of State, Frank LaRose, that he had it wrong, and that in fact, under state law, there can be more than one drop box in each county. Then LaRose said, well, I'm not going to follow that. It was not an injunction. It was a declaratory judgment. It was just a statement of rules. And so the judge said, I'm going to consider issuing an injunction, which the court eventually did. But in that small period of time after the judge issued a declaratory judgment and before the injunction, the Ohio Republican Party issued a press release and said, well, this was a Democrat judge who was deciding things to favor his allies. And you had the state Supreme Court Chief Justice, Maureen O'Connor, who is a Republican, issue a statement condemning the Ohio Republican Party for impugning the integrity of the judge and saying he was making these decisions because he was a Democrat. And so I think it's really important to differentiate between judges having different ideological views and different ways of viewing the world versus judges deciding cases in order to help the political party from which they came. I think at the Supreme Court level and for virtually every judge everywhere, just before we got on here, the Pennsylvania Supreme Court divided 5-2 over whether the Green Party should get on the ballot. 5 Democratic elected judges said the Green Party's off the ballot. And of course, the Green Party might take votes away from Democrats. 2 Republican judges said, well, no, I think we should send this case back and maybe they should get on the ballot. I don't think.
We've lost your audio. There we go.
I think I'm back now. I don't know what happened there.
Yeah.
I do not think any of the 7 justices on the Pennsylvania Supreme Court are partisan hacks. They're not voting because they're saying, how can I help my party get elected? But they do tend to see the world in different ways because of the, the media they have, the experiences they have. And this ends up coloring a lot of what happens. And when, to go back to your first question, when you have a constitution that doesn't really provide strong protection for voting rights, there's a lot of discretion in the hands of judges to decide things one way or the other. And when you have that discretion, motivated reasoning can kick in, and the arguments that seem to help the side that you're more sympathetic to might resonate more with you subconsciously than otherwise.
Oh, interesting. Well, let's shift the discussion a little bit and talk about 2 issues that are frequently debated when it comes to voting that judges will, I'm sure that judges will have to deal with. Fraud on the one hand versus voter suppression on the other. That's big in politics right now. We've had fora at the law school where we discussed and debated the prominence of one versus the other. And of course, depending on one's worldview about which one is more predominant than the other, that guides the policy recommendations that one has. I'm going to ask you, since it's Constitution Day, you're the expert on election law, which is more of a problem? Or is it fair to ask which is more of a problem? Are they equally problematic, fraud versus voter suppression? Or is one much more prominent than the other and worthy of greater attention?
That's a great question. I write a lot about that in my book, Election Meltdown, and I wrote about it 8 years ago in my earlier book called The Voting Wars. And I think in the 8 years from the first book to the second book, I think we've learned a lot. And there's been a lot of studies of the prevalence of voter fraud and more broadly election crimes in the United States. And what we can say is that election crimes and voter fraud are quite rare. They do not occur with a lot of frequency. And the kinds of crimes that, for example, might support a voter identification law where one person goes to the polling place. I go to the polling place and say, I'm Verna. People are not going to buy it. And so it turns out to be not a way to steal an election. Absentee ballot fraud, which is a very hot and controversial issue in this election, is somewhat more frequent. than other types of fraud, simply because ballots are out of the hands of election officials for some period of time. So they can be tampered with, they can be stolen, etc. But still, the amount of such fraud is quite low. And there was a great study that was done back in 2012 looking at all of the election crimes that prosecutors prosecuted from 2000 to 2012. So in a period where there were well over 1 billion ballots cast, you had 491 prosecutions. Not all led to convictions. And almost all of those involved very small kinds of crimes that would not affect the outcome of an election. They were still crimes, they should still be punished, but they would not affect the outcome of an election. Like we just had a case here in LA where a son voted his dead mother's absentee ballot in 3 elections. So those things happen, but they're not organized efforts. There are occasional organized efforts to use absentee ballots to try to affect an election. We saw this in 2018. A Republican political operative tampered with absentee, or has been alleged to have tampered with absentee ballots in North Carolina's 9th congressional district. The tampering was so worrisome that the State Board of Elections, a bipartisan board, unanimously called for a new election and to redo that election. We also have a case in Paterson, New Jersey right now, where an all-mail ballot city council election looks like there were maybe 800 ballots that were fraudulently tampered with. And there are both criminal charges pending and a new election being considered. But these are rare, and it would be very difficult to try to do this kind of crime in an undetected way, especially in trying to swing something like a presidential election. You'd have to be dealing with thousands and thousands of ballots. Voters would know. They would go to try to vote. They'd find out that they can't vote because a ballot has been sent in from someone else. So it'd just be extremely difficult to pull this off. And so the amount of fraud, it's not a non-problem when it comes to something like absentee ballots, but it's a very small problem. It's a very manageable problem. And states have all kinds of things like signature matching and ballot tracking and affidavits, all kinds of ways of making sure that this kind of crime is extremely rare. When it comes to voter suppression, I think it's fair to say that many of the laws that have been passed in the last decade and a half, primarily by Republican lawmakers, have been intended to make it harder to register and vote. Because they don't really seem to serve an anti-fraud purpose. They don't really seem to serve a voter confidence purpose. But the evidence that they're actually suppressing a lot of voting is much less clear. So, for example, voter ID laws have been studied a lot, and they don't seem to have that much of an effect. I mean, there are some studies that say maybe they have a 1 or 2% effect, and those effects might disfavor Democrats or might disfavor minority voters, but the effects tend to be somewhat small. That might be a little surprising. Part of the reason is people who lack IDs are the ones who are at the margins more of society, and they're less likely to be voting anyway, partly because Democrats and others do outreach activities to make sure that people get those IDs, efforts that they could otherwise be putting into getting out the vote, they have to put into getting people IDs. But there are some laws that are suppressive, and I write about one in Election Meltdown that I think we can show has a real effect. So Kansas passed a law that required anyone who wanted to register to vote, newly register to vote, had to provide documentary proof of citizenship, like a birth certificate or a naturalization certificate before you could register to vote. And before a court issued an injunction barring this, and the court eventually struck this down, 30,000 people had their voter registrations put on hold and were not going to be able to vote. So that's a real impact. 30,000 voters in a state is significant. The state tried to defend the law by saying there was a big problem of non-citizen voting, but the state could prove very little non-citizen voting, just a handful of cases, which the defendants described as the tip of the iceberg. And the federal district court judge issued an opinion where she said there was no iceberg. There was only an icicle made up mostly of administrative error. She said, the same things, that people point to. Some people are registered as having been born in 1800. It's a data entry error rather than some kind of attempt at fraud. And so, when you look at all of these things, what I think you see is that There's not a lot of voter fraud. Many of these laws that are passed that make it hard to register and vote are intended to suppress the vote, but many of them don't actually suppress the vote very much. Some that do are really worrisome, and those are ones where I think it's very important for courts to get involved and to say that you can't engage in that kind of activity.
Okay. Well, to continue on some of the examples that you talked about in your book, you talk at length about the incompetence. I mean, that I found really surprising, the level of incompetence in running elections. Can you share with us, talk a bit about that and the extent to which it is problematic? And I guess, what do you think that means for November 2nd, which is election day?
Yes. So, in election, November 3rd.
3rd, sorry.
Yes, let's not give voter misinformation. There's nothing, Democrats vote on Wednesday, there's misinformation. So, November 3rd.
Well, you can always come back and vote again. No, you can't.
Well, the president has suggested that, go back a second time and check your ballot.
Yeah.
So I do talk in Election Meltdown about pockets of election administrator incompetence. And this is something that's, equal opportunity, that is both Democrats and Republicans have their poor election administrators. We tend to focus more on the Democratic poor administration because it tends to happen in bigger cities, and bigger cities tend to be more Democratic. And so, but we have examples of both Republicans and Democrats engaging in this. I do think that when an election is very close, we tend to focus our attention on what I call the weak links, those that do the poorest, because if you're an election lawyer and you're trying to change the results or get an election redone or something, you're going to look at the places where there are problems. You're going to focus on those weak links. So it is problematic, even if 95% of election administrators are doing a terrific job, that a small group is not. In this current era, this pandemic era, we have a bigger problem, which is that election administrators are being asked to make huge changes to how elections are run in a very short period of time. So it's true that there are 5 states that have had all vote by mail, or mostly vote by mail elections, but they've had, and they're run very successfully, very little fraud. A lot of voters are very satisfied with those systems. And this includes the heavily Republican state of Utah, that as well as Colorado, Washington, Oregon, Hawaii. Those are the 5 states. They've got it down, but now we're seeing election administrators in other states being asked to ramp up mail-in balloting in a way that they never have had to before. So to take one example, in Georgia in 2016, about 36,000 people voted by mail in the primary. And in the 2020 primary, it was 1.1 million. So really just tremendous uptick. And what we've seen is that in some places there really have been some problems in how especially mail-in ballots were handled, and delays in counting the ballots. It's taken weeks in some places to get the ballots counted because we have all these anti-fraud protections on absentee ballots. You have to make sure that the signatures match, or that there's other identifying information, make sure the person is signed where they need to sign, and do all those steps. That takes time. So there's now fighting in Michigan and Pennsylvania and other places too, but those are 2 places I'm watching really closely for the upcoming election, because those are 2 swing states, and there are 2 states that have just now moved to all mail, not all mail, no excuse absentee balloting. And a lot of people want to vote by mail in both of those states. In both states, there's now a fight over whether election administrators can start the pre-processing of those ballots before election day. And this has become a political fight. Democrats wanting and clerks wanting to have the right to count, Republicans resisting. And so, it's become yet another political battle. So even in the time of coronavirus, the same kind of political battles over voting have taken place. Part of the reason I think that there's some resistance has to do with the president making these unsubstantiated claims that there's massive voter fraud with vote by mail. And so it's kind of made things messy. And maybe the worst piece of this is that Congress has not provided enough money for the states to be able to ramp up not just safe voting by mail, but safe in-person voting. It's going to be more expensive to run polling places when you have to have PPE and social distancing, and it's going to take longer. It's hard to get workers, there's all kinds of things. And so without adequate funding, I think we are in danger of more places running things in a sloppy way. And the sloppiness is not good in an election system when we're really polarized and people are suspicious that the election's not going to be fairly run. And so I really do worry that some of those pockets of incompetence are going to come back to haunt us if we end up having a very close election.
Okay. And you talk in the book about one of the results of this kind of mess, for lack of a better word, is people's disgust with the political system. They basically check out. So we have fewer and fewer people participating in the democracy, which again, it just creates an endless, a terrible cycle for us as a nation. Well, I wanted to ask. We've talked at length about the problems. The lack of constitutional protection. Tell us how to fix it. What legal measures can be taken to improve our electoral system?
So, I think that we can think about this as having both a short-term and a longer-term time horizon. Short-term, I think, there needs to be education of the public right now and of the media that election results may be delayed because of all of the problems that I've mentioned. And that delay doesn't mean that the election is being stolen or rigged, and it's not a time for candidates to prematurely declare victory if there are still votes that are left to be counted and we're not sure who's won the election. So I think there's a lot of education to happen there. I think as an individual, the most important thing that you can do is to have a voting plan, figure out when you're going to vote, and vote as early as possible once you've made your choices. If there's early in-person voting or vote by mail and you want to vote in that way, you should take advantage of it and not wait for election day. We don't know what election day is going to look like in terms of lines because, polling places may be closed because of the difficulty of finding poll workers who are often drawn from older Americans who are less willing to serve as poll workers. We don't know how many people are going to end up voting by mail or think they're going to vote by mail and then decide, no, I'm actually going to show up. There are real questions about what election day is going to look like. So, and also because we have a really decentralized election system, everyone should be able to check in with their local election officials and ask them what their plans are, how they're going to be transparent about how the voting process is going to take place. If you're really ambitious, volunteer to be a poll worker. That's really important work. And I would say that young people, college students, law students, there's been a lot of effort in law schools to try to give students the opportunity to work as poll workers if they can. Longer term, I think we need bigger changes. We shouldn't be going through every 4 years this question about who gets to vote and are we going to have a successful election, all of that. I actually would favor move towards national standards for how elections are run, or even having a constitutional amendment that would create a national nonpartisan system of election administration. Take it away from the states for the conduct of our national elections. That's a long-term project. That's not happening anytime soon. I do think we should raise standards, and I'd like to see that happen as soon as possible.
All right, great. Now, I also thought it was interesting. You admitted, I shouldn't say it like this, that sounds very loaded. You admit that you changed your mind on a constitutional amendment around the right to vote. What is it that changed your mind, as if we don't know?
So I always have felt, I've been teaching since 1994, and I've always felt that when someone gets to that point in their paper where they say constitutional amendment, it's because they really are throwing up their hands, because constitutional amendments are so difficult to pass. But what really changed my mind, I'd say, was two things. One was kind of the images of those voters standing in line in Milwaukee waiting to vote, and thinking, 50 years after the Voting Rights Act, to see these pictures of people being disenfranchised by this system is really problematic. But the other thing is, I just finished a different paper with Professor Leah Littman of the University of Michigan. That was part of a symposium on the 100th anniversary of the 19th Amendment passage. The 19th Amendment is the amendment that gave women an equal right to vote. And what we saw was that the struggle for women's enfranchisement was a multi-generational struggle. It started back with Abigail Adams trying to get women to vote, but it took a really long time, and it became a political movement. And so there were really decades of activity, and we saw states in their state constitutions pass amendments that gave women the right to vote, and this energized the movement. And it seems to me that we need a long-term push towards greater voting rights, because I do believe in this idea of voter equality, and whether you live in Georgia or Montana or Ohio, you should have an equally easy chance to be able to cast a ballot that will be fairly counted. And so, that struggle culminated with the 19th Amendment. But then when that happened in 1920, there were still many, many women who were disenfranchised, women who married foreign-born men, for example, and African-American women.
Yes.
One of the great tragedies of the 19th Amendment was, you had assurances. Don't worry, this amendment by itself won't enfranchise African American women. So don't worry about that. We're just talking about white women. And so really, women's enfranchisement didn't really happen until the late 1960s, when the Voting Rights Act came in, and we really had extensive voter registration ever. So it was a multi-generational struggle, and it changed the country. And so I think that while I'd be perfectly happy to see Congress pass legislation to deal with a lot of these problems, and Congress has ample power to deal with a lot of these problems under Article 1, Section 4, which gives Congress the power to set rules for the conduct of federal elections. I think ultimately a political movement built around a constitutional amendment would be empowering, would actually promote voting rights even more. And it would also, if we could create this kind of commission, it would make it harder for parties to game the system going forward. It would kind of hardwire into the Constitution a structure that would give some independence to a neutral body to run our elections.
All right, great. Well, it's about 1 o'clock. I want to make sure we have time for questions from our audience. So feel free to put type your questions into the chat. I think Jenny may have some questions. Do you?
Yes, I do. So from Professor Moore, she asked, I apologize, let me scroll back up. 2 questions. Based on your very helpful analysis, might the blue-red liberal conservative Democratic Republic dichotomy in the view of voting rights be more accurately labeled as egalitarian, hierarchical, a more fundamental tension that is baked into the history and structure of the Constitution? And 2, do you see any likelihood that the surprisingly robust view of equal protection fundamental rights that seem to inform Bush v. Gore will play a role in what seems likely to be upcoming litigation over voting rights in the November election?
Well, those are both great questions. I'll take the second one first, because that's an easier one for me. So in Bush versus Gore, some of the law students who are watching are probably too young to have a good memory of this. Maybe my daughter's memory is of watching Bill O'Reilly yell at me on the O'Reilly factor. So, but in that case, which involved disputes over the counting of certain ballots in Florida. Florida used very bad voting technology. It was hard to tell in some cases who someone was voting for. In the end, the Supreme Court, on a 5-4 vote, said that the counting that had been required, the recount of ballots that had been required by the state Supreme Court, that this violated equal protection principles, because once the state grants the right to vote to voters, it can't be done in an arbitrary and disparate manner. And so many people thought and what was odd about this was this was an expansive view of what the Equal Protection Clause requires. It had never been applied before to the nuts and bolts of voting like it was in Bush versus Gore. What was odd about the case was that you had the conservatives embracing this very broad view of equal protection and the liberals rejecting it. Again, back to this idea of motivated reasoning in the midst of an election dispute. Many people thought that you could kind of make lemonade from lemons. So you could take this opinion, which actually stopped vote counting, and use it to try to create a robust equal protection jurisprudence that would expand voting rights. I can tell you that in the almost 20 years since Bush versus Gore, the Supreme Court majority has never cited Bush versus Gore for this proposition or any proposition. And in fact, it's only been cited once in a concurring opinion by Justice Thomas in a case where the issue was peripheral. In most of the lower courts, Bush versus Gore has not really had legs. That is, it's not something that the courts have relied on to see a robust equal protection jurisprudence. Instead, and I alluded to this earlier, and there's a lot more about this in my 3 pathologies paper, the courts have applied something called Anderson verdict balancing, which is a very flexible balancing test, which says when a state burdens voting rights just a little bit, the state has a lot of discretion to do what it wants. And when a state imposes a severe burden on voting rights, then it's limited, and we apply something like strict scrutiny. And I do think that that gives a lot of flexibility, especially because judges are going to differ into what they consider to be a severe voting rights problem. So, in short, I don't think Bush versus Gore is going to have much of an impact, at least its equal protection holding. I think the fact that Bush versus Gore so divided society is going to weigh heavily on the Supreme Court should they be asked to weigh in on election disputes coming around. And very quickly, because I want to get to other questions, on the other point, I do think that thinking about it as kind of an overlay on the egalitarian hierarchical view of what the Constitution is trying to do, and kind of broader philosophical disagreements about kind of how American democracy is organized. I think it does map pretty well onto that. And I think it's a great observation.
Okay, and then in addition, can you speak to what looks like a looming circuit split, 4th over 11th, over whether requirements that people with felony records pay fines and fees to obtain restored voting rights violates various constitutional rights? With respect to this and other hot voting rights issues, what's your view of any likely role that might be played by Justice Roberts' apparent interest in protecting the stature and reputation of the court?
Right. So we have seen courts divide, and again, dividing along ideological lines. It's a sad fact that it's often pretty easy to figure what the court's going to do when you know the kind of ideological predispositions of the judges. This played out most recently in a case coming to the 11th Circuit out of Florida. Florida voters had overwhelmingly passed a law that re-enfranchised felons after they had completed their sentences. In response to this state constitutional amendment, the Florida legislature passed legislation that said, you can't have your voting rights restored if you're a felon unless you've paid all your fees and fines. One of the problems that former felons in Florida face is that there's no central repository of information about fees and fines. And so an ex-felon who wants to be able to vote would have to sign a piece of paper under penalty of perjury saying, I don't have any fees and fines anymore, but they might not even know. And so this law was challenged. The district court said it was unconstitutional. And the entire 11th Circuit took the case en banc, and the 11th Circuit issued an opinion, again, where they divided along party and ideological lines, where the majority said that this procedure did not violate due process and was not a poll tax. I don't think that if this case gets appealed to the Supreme Court is likely to want to get involved before the election. So this is probably the end of the line for that particular case. I do think that the due process argument was a much stronger argument. In terms of what counts as a poll tax, the courts have been very wary of expanding the definition of a poll tax to include burdens on voters other than a literal poll tax. You have to pay $5 if you want to be able to vote type of thing. But the due process argument to me seemed very strong, which was that there was no way to know how much you owe, and so then it's going to chill people who were former felons from being able to sign up onto the voting rolls. More generally about Chief Justice Roberts, I think it's correct, as the questioner suggests, that he's trying to maintain the stature of the court. He's issued some surprising opinions where he's sided with the more liberal justices. He hasn't done that really in the voting rights cases yet. He's been much more of a reliable conservative. But if we end up with a Trump versus Biden kind of case at the Supreme Court, I expect he and Justice Breyer and Justice Kagan, who I think make up a kind of center of the court right now, would be looking for some resolution that wouldn't divide the court along a 5-4 basis. If we'd have a repeat of Bush versus Gore, but we'd have it in a kind of Twitterized, polarized atmosphere, which I think would be very dangerous for kind of the peace in our society.
Jenny, more questions?
I apologize. I started asking a question. From Barbara Howard, can you comment on the current structure of the Electoral College and whether we need to look at changing or eliminating it? What are the pros and cons?
So, the Electoral College gives an advantage to those states. It gives a kind of a numerical advantage to those states that are smaller. They get more representation because part of the Electoral College numbers are based on population. Part is based on the fact that every state, it's based on the number of senators and representatives you get. So that gives kind of a boost to the small states. It certainly makes the swing states the most important. So I think, Ohio used to get a lot more attention when it was seen as a swing state by presidential candidates. Now, it's Michigan and it's Pennsylvania, North Carolina, Florida, always, and so I think that, the Electoral College is not in line with our current thinking about one person, one vote. It was created, as I mentioned earlier, under a system where state legislatures set the rules, and state legislatures initially didn't even give people the right to vote for president. This was an activity done directly by state legislatures. But if we continue to have a series of elections where the popular vote winner is different from the Electoral College winner, there's an analysis that statistician Nate Silver did that said something like, if Biden beats Trump by 3 to 4% in the national popular vote, he still only has a 50-50 chance of winning the election. That's pretty incredible that there's this dichotomy. That said, I don't see an easy path because it would require a constitutional amendment, and which would include the votes of those states that benefit from the current Electoral College system. I don't see how we easily amend the Constitution to eliminate the Electoral College. There's been some proposals to try and get around the Electoral College by creating a compact of states. When enough states representing 270 Electoral College votes agree, they would pledge all of their votes in favor of the national popular vote winner rather than whoever wins the particular state. I think this is a well-meaning proposal, but I oppose it because I think that there could be a lot of mischief. A state could try to pull out at the last minute. There are constitutional questions about whether you can make this end run around the Electoral College. I think the goal is to try to eventually spur Electoral College constitutional amendment reform. That's something I would support, but not this end run, because I just think it's too risky, especially in this environment.
Okay, we have time for one more question, Jenny.
Okay. Let's go to then. Using your proverbial crystal ball, what do you predict for this fall's election? In particular, do you expect a reprise of the kind of controversy that we saw in the 2000 election?
So I think if the election is very close in a state that matters for the Electoral College outcome, it's going to be much worse than 2000 because now we're more polarized. We have a president who's made statements that are saying that if the election is if he loses the election, it's because it's rigged. You know, there's a lot of people on both sides who believe that the other side is trying to steal the election. You've got social media that allows for misinformation to spread. So if it's very close, I think it would look worse than 2000. The good news is that the chances of it being that close are not all that high in any particular election, because it has to be close not just in a particular state or overall. It has to be close in a state that matters for the Electoral College outcome. And I hope that we're not in such a situation. So if we are in a situation that comes down to Pennsylvania and we have to wait 3 weeks for Pennsylvania to count its votes, I think that would be a very tough situation for the country. But odds are that it won't come down to that. And I think if that's true, then we would have dodged a bullet. And so I guess I should end this as I end a lot of my talks with the election administrator's prayer, which is, Lord, let this not be close. Because when it's close, that's when all of the infirmities in our system are revealed.
All right, that's a perfect way to end this conversation. Thank you so much, Professor Hasen. At this point, you can unmute your audio, and let's give him a nice round of applause for this provocative conversation. Thank you.
Thank you so much. I enjoyed it.
So glad that you could join us. Right.
With some of your students later on.
Thank you. Take care, everyone. Thank you for joining us. Bye-bye.